Good morning to all of you. The Honorable Supreme Court, three judges bench, consisting of Justice N. Ramana, Suryakant, and Anirudh Bose, on 5th March 2021, reiterated that the anticipatory bail given to an accused at one stage does not automatically come to an end when the charge sheet is filed. This is what the Honorable Supreme Court also stated. It was already emphasized in the very famous case of Sushila Agarwal and others versus State within bracket NCT of Delhi 2020. You can see that case also. You know that whenever a person apprehends that he will be arrested on a false charge, whatever it is, he will be accused of a non-bailable offence, then he can file an application for grant of bail under section 438 of the CRPC. Right? So section 438 CRPC gives enormous powers to the Sessions Court as well as to the High Court, either to grant or not to grant bail to the accused. So normally it so happens that the Honorable Court may give a direction that in case, according to section 438 clause 3 CRPC, in case he is arrested by the police, he has to be released on bail with some conditions or with some sureties or things like that. On some occasions, the Honorable Court may direct the person who is apprehending arrested to surrender himself before the court on before 15 days or 20 days like that and get bail. Right. That process is over. Normally, a person apprehending arrest under section 438 CRPC, he filed the bail application, he got the bail. So normally, when once the charge is filed after completion of investigation under section 173 of CRPC, they will file, the police officers will file so-called final report or charge sheet. And once the charge sheet is taken on file, they will give once again the PRC number or SC number, or if necessary, they will commit it to the Court of Sessions, designated court like that. At that time, the accused has to appear before the court. He has to be supplied copies of the documents under section 207 CRPC. He will be examined. Of course, he will be examined as a preliminary examination. Then he will be, the matter will be committed to the Sessions Court. This is the local procedure. So after filing of the charge, when once he appears, then the court normally asks him, "Arey Baba, the anticipatory bail given to you before filing charge sheet is completed by now." Now, since the charge sheet is filed, since it is taken, the court has taken cognizance, then once again you have to apply for a fresh bail, or then the conditions will be imposed him that he has to surrender before the court and he has to apply for regular bail. This is not correct as per the Supreme Court decision in this particular point. So, while disposing the case of or anticipatory bail petition of or criminal appeal in regard to anticipatory bail petition of Dr. Rajesh Pratap Giri versus State of Uttar Pradesh in criminal appeal numbers 272 and 273 by 2021, which arose out of SLPs 693 and 694 by 2020. Right. So on 5/3/2021, the three judges bench came to the opinion that anticipatory bail, once guaranteed by the court, cannot come to an end with the charge sheet. That means it will apply throughout the trial of the case. So this procedure will be followed, has to be followed hereafter. Right. So now let's go into the details of the case. The applicant, Mr. Rajesh Pratap Giri and another, they were granted bail by the trial court on some day in 2019, 21/10/2019. They were surrendered. Yes, they are surrendered with the court. Of course, they did not surrender. They were surrendered before the court. Right. Later, the police completed investigation and charge sheet was filed. Right. The trial court indicated that the anticipatory bail granted came to an end by the filing of the charge sheet, and you have to surrender and you have to get a regular bail by filing regular bail application. Basing on this, he filed an application before the Honorable High Court of Uttar Pradesh. It was rejected, and once again he has requested for the modification of the earlier order of the High Court once again on 20/12/2019, but they did not accept. Ultimately he came to the Supreme Court, and he based on the famous case of Sushila Agarwal versus State NCT Delhi, where it is clearly stated and emphatically stated that once the bail is granted, it is bail. That's all. And whether it is anticipatory bail, regular bail, and you granted a bail, it's a bail. That's all. It will continue till the trial and till the end of the trial of the cases, right? Of course, the state argued that he did not attend before the police, even though the directions are there. All these things they have stated. Of course, they are not much material here. So please remember, this court concluded the mere fact that an accused was given relief under section 438 CRPC at one stage does not mean that on filing the charge sheet he has to surrender and apply for a regular bail. It is not correct. The High Court also has erred as per the relief given by the Supreme Court. Very good judgment will occur to you also. Normally the courts will be asking, come on, surrender and get bail, regular bail. All these things are not necessary. So you can cite this case as a precedent. Good case, read it and develop your legal knowledge. Thank you very much.